It's just taking my computer a little bit longer to start up. But we're gonna make it happen. Oh, and Bashan, you know what's in that box, don't you? Yeah.
I think that goes far.
I know. Oh, yes. Oh, no. All right. Brittany Cruz. All right. And just after they finish swearing them in, we'll start. All right, court is calling 2022 CR 10787, State of Texas versus Brittany Cruz. Can I have parties announced for the record for the state?
Debbie Cruz on behalf of the state, Your Honor.
Defense?
Somebody is not right now.
Are you Ms. Cruz?
Yes, ma'am.
Counsel, had you received all the discovery in this case and did you review it with your client?
Yes, ma'am.
Court will find that the state is in compliance with discovery. If you all could either whisper in the box and move to the other end so the court reporter will be able to hear. All right, Ms. Cruz, I'm showing you what's entitled application for deferred adjudication or community supervision. Did you review that with your attorney? Did you understand?
Yes.
Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
Yes, ma'am.
State, are you proceeding on the indictment as presented?
We are, Your Honor.
Ms. Cruz, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney? Did you understand it and did you sign it in all the appropriate places? Did you understand you're charged with the offense of possession of a controlled substance, penalty group 1 gram to 4 grams as a third-degree felony? The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea bargain agreement in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine? Did you understand? Counsel, has your client been able to provide you with any defenses?
She has, ma'am.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, ma'am.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, ma'am.
Ms. Cruz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney? Did you understand it? According to the plea, The state is proceeding on the indictment as presented. There's $1,000 fine. State recommends deferred adjudication, and there's to be restitution to the Bear County Crime Lab for testing. Did you understand that to be the plea? Defense?
Yes.
State?
Yes.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your term of deferred adjudication be for 2 years. There be a TAP evaluation, 150 hours community service restitution, and drug education course. Did you understand those were recommendations from the state and the court does not have to follow those recommendations? To the offenses charged, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence?
At this time, the state introduces State Exhibit 1 and all of the attachments, Your Honor.
No objection.
All right, state, you can confer.
Thank you.
All right, Ms. Cruz, I'm showing you what's entitled Waiving Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
It's her first felony offense. Seems to be doing well. She's working part-time right now, cleaning homes. We're asking the court to grant her application.
All right, who is Sergio Huerta?
That's my ex.
Do you have any children with him?
No, I don't.
Do you have any children?
Yes, I do.
How many?
2,
Ages?
11 and 10.
Where are they?
My daughter's with my ex's sister, my ex-sister-in-law, and my son is going forward with my mom.
All right, so was Child Protective Services involved?
Yes,
And were your rights terminated?
yes.
Are those the only 2 children you have?
That was
What have you,
14.
are you living by yourself?
No, I live with my boyfriend.
Does he have any children?
Yes.
Do they live with you?
They live with me. Well, I'm staying there, so just,
I mean, do the children live with him?
yes.
And what are their ages?
18 and 2 twins are 16.
All right, any children under the age of 16?
No, ma'am.
Where, just as a side note, where is their mom?
Oh, well, they're going through a whole, that's,
Okay. When you,
Yeah.
when you're drug tested today, what are the results going to be? And you are going to get a drug test today.
yes.
What is the result?
Yes.
All right, when's the last time you used?
A couple of weeks ago, I believe, but I've been.
What did you use a couple of weeks ago?
Maybe like 3 weeks.
No, what did you use? What substance?
Oh, methamphetamine.
Okay. All right, any other questions?
Just to clarify, Judge, the CPS case was in 2013.
Yeah,
Okay.
still providing for them.
You give her money,
Yes, yes.
and she does send her daughter.
All right, 2 years deferred adjudication, $1,000 fine, probated. Restitution to the Bear County Lab for testing. No unsupervised contact with minors. No contact with Sergio Pablo Huerta. Drug education course. I want 90 sober meetings in 90 days. 150 hours community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. Court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. I'm going to order parenting classes because there are minors that she's in contact with. And if she ever intends to have any contact with her 11-year-old and 10-year-old, she's going to need parenting classes. Once she completes the parenting classes, the remaining of the community service hours can be waived. I'm going to want proof of employment within 30 days. There's to be no employment as a home health care provider, no employment with minors, and you are not to be employed at any location, restaurant, whose primary source of income is through the sales of alcohol. You understand? I'm going to want a TAP evaluation, and you need to be honest in the TAP. If the TAP evaluation recommends inpatient treatment, I'm going to want intensive outpatient treatment. If it recommends outpatient, supportive outpatient, I'm still going to want intensive outpatient treatment. There's going to be regular reporting by Zoom or in person. We're going to do the UA hotline with her, and we're going to do the UA hotline with her for at least 3 months, and we'll see how that goes. If all goes well, then she can go to regular testing. And I'm going to want field visits 2 times per month, and we can do that for 3 months and see how it goes. Probation, is there anything else that she needs? Yes. Is there anything else that you need from the court in order to be successful?
No, not that I could take over now.
All right. In this court, your attorney will tell you communication is key. When people are placed on deferred adjudication or probation, I want them to be successful. I don't want to have to send somebody to prison. Many of the people that you see over in the box, they were either on probation, didn't communicate, didn't report, or whatever they did not do. You understand? Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, good luck to you. We can go off the record. Here's the thing, meth and all of these drugs that people are doing on the street, you don't know what's in them. Maybe the last time you use it, don't let that be you, okay?
Thank you.
All right, you're welcome.
That'd be Susan.
Yes, and she'll just sit on the front row. All right, who's here on John Alberto Casanova Paez? All right, if your client can, is your client here? Yes. Come forward. All right, so we're here. There was an agreed bond on January 24th. The discovery acknowledgement was signed. So I'm assuming you have all the discovery.
We do, I believe.
All right, was an offer tendered?
Yes, we received an offer today.
Okay,
So Judge, I'd like to have some extra time. I don't know what you normally do for a plea deadline, but I want to have an opportunity of at least 60 to 90 days to put together some mitigation before we come back for the plea deadline.
I don't give 60 days for plea deadline dates. I'll recall it in 30 days. Ms. Ferguson? Plea deadline date, 30 days, please. All right, March 28th.
So that doesn't give me a chance to really adequately represent my client, Your Honor. I want to put together a mitigation packet.
This case has been on my docket since December.
Yes, he's, you could see, I don't want to say what the charge is, but you can see on your docket what the charge is.
Yes.
I consulted with a couple of different treatment providers to try and get him in treatment, and they're not taking extra people. I have more names of people to call, but I would like to be able to present that he has already received treatment.
We'll see where we are on March 28th, but for now, that's the plea deadline date. You're welcome. Johnny Webb. We're just waiting for your attorney. Just have a seat. Nathan Gomez. All right. Court is calling 2021 CR 6162 State of Texas versus Nathan Luis Gomez. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
Veteran Polly for the bench round.
All right, and are you Mr. Gomez?
I am now.
Showing you what's entitled motion to revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
Are you the same Nathan Luis Gomez who was placed on community supervision for driving while intoxicated second on November 9, 2021 for a term of 18 months? Is that you?
That is correct, ma'am.
All right, state.
Violated condition number one, on or about the 22nd day of February 2022 in Bexar County, Texas. The defendant, Nathan Luis Gomez, committed the offense of terroristic threat in violation of condition number one.
How do you plead to that? True or not true?
True, ma'am.
Your Honor, state waives all the violations.
Any objections?
No objections, Your Honor.
All right, Mr. Gomez, did you understand by pleading true to violation of condition number one, court could find it true, grant the motion, sentence you to 1 year in the Bexar County Jail and
Yes,
up to $800. Did you understand?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number one?
I would like, yes, ma'am.
Court will find violation of condition number one true. Is there an agreement?
Judge, there is one part where we are not agreed, which will be led to the court, but I'll leave that for last. It's to alter and amend to extend the defendant's probation to be at least 1 year from today. I believe that's 9 months. That's a 9-month extension.
Okay,
Register for the DWI intervention class within 10 days. Weekly UAs.
excuse me, just 1 second. Excuse me, you all in the box? You all are talking behind the court reporter. It's making her job more difficult. All right,
I'll start from the last one. Register for the DWI intervention course within 10 days, weekly UAs for 60 days in lieu of an abuse. GPS tracking only. That's where we're disagreeing, Judge. It's state's recommending 3 months, defense wants 2. No contact with John Hilliard, his home or workplace. And for the defendant to restart IOP with Bexar County. And the state's going to take into consideration County Court cause number 692945.
all right. This John Hilliard and no contact with the work location. What work is that?
It's a high school. I spoke with the complainant. I didn't get the name of the high school in speaking to the complainant.
Oh, what's the name of the high school?
Linear High School, ma'am.
Thank you, sir.
You will.
All right, is that the agreement?
Yes, Judge.
All right, and you want to address the issue of GPS tracking?
Yes, Your Honor. Just briefly, my client has managed to get his associate's degree from San Antonio Community College. And he is applying for various jobs. He also has a certificate in medical billing and coding. I just think that maybe for a couple months he can hold off on not getting, these job interviews, but if they see an ankle monitor, obviously that I think they'll adversely affect it possibly for employment.
Well, I could be wrong, but I think the new number one may adversely affect his employment abilities. I mean, I don't know anything about the new number one in this case. But I do know you haven't been doing what you're supposed to do on probation, and I know that the state didn't consider any of these other allegations in the motion. So I'm not taking any of that into consideration or not, but I don't see why he shouldn't be on GPS. I mean, he's on probation and he picked up a new offense.
I just say GPS for just a couple months, Your Honor.
But I don't have a good reason why I should just give it to him for 2 months when he's been on probation. What has he done since he's been on probation?
Your Honor, I believe he has, this is why I was talking about his educational qualification.
No, I mean, has he completed anything that's been ordered for him since he's been on probation? What has he completed?
The victim impact panel, the DWI education course, I believe.
And
Probation, what has he completed?
The victim impact panel and his staff evaluation, Your Honor. He was turned unsatisfactorily on the fair outpatient program, and I can tell you which one exactly.
And I believe he was picked up on
Oh,
that new number one, which caused him to not be able to complete it, Your Honor.
Okay.
that was the instance of outpatient.
All right. All right, do you have any children?
No, ma'am.
Okay, this is what the court is going to do. Court will find number one true, extend 9 months. You to enroll in DWI intervention course within 10 days of release. There's to be GPS tracking for 4 months. No contact with John Hilliard or Lanier High School. Are you going to re-enter the intensive outpatient treatment?
Yes, ma'am.
I'm going to want 90 meetings in 90 days.
Is that a restart of what I already have?
Yes. Taking consideration county court cause number 692-945. And we'll do weekly UAs. Counsel, if he's doing well on GPS in like 2 months, come back and the court will consider removing that.
Will do, Your Honor.
But once he has a track record since he's been out of custody, I'm always open to with you on any of this, then don't come forward, okay?
Yes, ma'am.
All right, is there anything else you need from the court?
Your Honor, as far as the GPS fees, I just want,
I'll ask that they be waived, but I can tell you, I will put waive fees, defer fees, but the whole issue is that's third-party contract, and I really have no jurisdiction over them. But I'll put in there that the fees are to be waived or deferred, and we'll see what happens. I already know what's going to happen, but we'll see, and it's a part of the order.
okay, thank you, Your Honor.
All right, and if there's an issue with him being able to pay fees, let the court know.
Will do, Your Honor.
Okay. Thank you. Joshua Gonzalez. Joshua Gonzalez. All right.
Well, I mean,
Hmm.
I don't know if she's finished, so we.
We go in order of appearance. So this is, he has another case that you were trying to get the discovery on. This is Joshua Gonzalez, right?
Yes, Judge.
And so what I have happen on,
Is that case? I don't think they're gonna be filing that case.
okay, because what I had happen on December is that there was a new case that you needed discovery on.
Right, so right now, we're not concerned about that case. They've made a very good offer to my client, Judge. It's just there's one thing that we want my investigator to take care of before, so I was wondering if you could set us for a plea deadline.
Sure. How much time are you asking for?
30 days would be great.
Okay. Ms. Ferguson, can I have a plea deadline date for Mr. Gonzalez, 30 days, please?
Thank you, Your Honor.
You're welcome.
I can do the 30th.
All right, we're going to come back on March 30th. That will be your plea deadline date. What that means is the court will not accept any pleas in this case after that date. Otherwise, you'll have to plea open for the court, and I'll only consider accepting a plea with good cause. Do you understand?
Yes, ma'am.
Okay. All right. Thank you. Is there anything else?
No, Your Honor, thank
All
you.
right, you're excused. All right, who's here on Robert Reyna? Okay, if you'll come forward. And probation, this is going to be probation. All right. Court is calling 2022 CR 5519, State of Texas versus Robert Reyna. Can our parties announce for the record for the state?
Jason Garrett, Your Honor.
Defense,
Tracy Franklin, defense.
are you Robert Reyna? Counsel, have you received all the discovery in this case and did you review it with your client?
Your Honor, I've received everything except the standing order for blood discovery was signed, but our office hasn't received that yet. But because you were able to come to an agreement, our office will not be needing to get that discovery after all.
All right. And Mr. Reyna, you understand that that's the discovery that your attorney does not have? Knowing that, do you still wish to proceed with this plea? And do you understand that you have a right to have that discovery? And knowing that you have a right to have that discovery, do you still wish to proceed with this plea? All right. Mr. Reyna, I'm showing you what's entitled application for community supervision. Did you review that with your attorney? Did you understand it? Next, I'm showing you what's entitled true bill of indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, but we have an oral amendment, Your Honor. I
Yes.
spoke with defense counsel about I guess the second paragraph, the portion that has the cause number, it currently reads CC 69910. The state would be asking to orally amend that to read CC 669910.
No objection. Ma'am.
All right. Mr. Raina, do you understand that's a substantive change to the indictment? Knowing that, do you still wish to proceed?
Yeah.
And you understand that your attorney has 10 days from presentation of the indictment to prepare for trial? Knowing that, do you still wish to proceed? Okay. All right. Any other changes to the indictment, state?
No, Your Honor.
And are you proceeding on the indictment as presented with the repeat offender paragraph?
Yes, we are, Your Honor.
All right, Mr. Rainey, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Do you understand you're charged with driving while intoxicated third or more? Normally, that's a third-degree felony. The range of punishment will be anywhere from 2 to 10 years in prison and up to a $10,000 fine. But because the state is presenting your indictment as an enhancement, if the enhancement is proven to be true, it will be a second-degree felony punishment, and that punishment will be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Do you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Raina, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Has anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes.
Are you a U.S. citizen? Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that with your attorney? Did you understand it? According to the plea, punishment is to be assessed at a cap of 10 years in the prison. The state, you are to agree that you've been previously convicted of a felony for enhancement purposes. There's a $2,500 fine. State opposes your application, and there's to be restitution of $1,500 to Vanessa Castillo. Did you understand that to be the plea? Defense? Is that the
Yes,
plea?
Your Honor.
State, is that the plea?
It is, Your Honor.
And I'm sorry, Mr. Raina, I spoke over you. Is that the plea?
Yeah.
Next, I'm showing you what's entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? I'm sorry? And with regards to the enhancement, how do you plead to that, true or not true? State any evidence.
Yes, Your Honor. State exhibit number along with all the statutes.
Any
No.
objection? All right, state, you may be excused.
Thank you.
Thank you. Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and review the same. All right, after reviewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancement true based upon your plea or true, and also based upon state's exhibits 1 and attachments. This will come back on April 10th for sentencing. I'll base my decision on your application based upon the PSI report I received and any other information that's submitted. I'm going to request a PSI and TAP eval. Is there anything else?
Nothing further.
All right, thank you. Have a great day. He'll need to check in with probation. Jesus Marcelinos. Who's here on I'm sorry, Joshua Marcelios. You can tell I don't have when I don't have my glasses, right? All right, the court is calling 2022 CR 9839, State of Texas versus Joshua Marcelios. Can I have parties announced for the record for the state?
Ruben Herrera for the state, Your Honor.
Defense?
Matthew Brown for Mr. Marcellus.
And are you Mr. Marcellus?
Yes, Your Honor.
Counsel, have you received all the discovery in this case and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Marcellus, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Your Honor, we'll be proceeding on the lesser included, class A misdemeanor assault, bodily injury, married.
Any objection?
No objection, Your Honor.
Mr. Marcellus, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with assault, bodily injury, married, or cohabitation? That's a Class A misdemeanor. The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, I do.
Mr. Marcellus, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, punishment is to be assessed at 1 year in the Bexar County Jail. There are no applications. This will run concurrent with 689-550. There's an affirmative finding of family violence and no contact with the complainant. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, ma'am, I do.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, ma'am.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
It is, Your Honor.
Showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offense of assault, bodily injury, married, cohabitation, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
None, Your Honor.
I'm sorry?
None.
No, any evidence
Oh.
to support his plea?
1 second, Your Honor. Yeah, the state offers state exhibit number 1 in all cases.
All right,
No
any
objection.
objection?
No objection.
All right, you can be excused to continue to confer.
Thank you.
Thank you. You're welcome. Mr. Marcellus, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney?
Yes,
Did you
Your Honor.
understand it? Did you sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor, I understand.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor, I understand.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will find you guilty. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just ask you follow the agreement.
All right, the court will sentence you to 1 year in the Bear County Jail. There's an affirmative finding of family violence. There's to be no contact with Kyla, Kyla Biederman, Biedermann. Credit for any time served. Taking consideration, concurrent with 689550. Anything else with regards to sentencing?
No, Your Honor.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you need to speak to an attorney. You understand?
Yes, Your Honor.
All right, we can go off the record. How old are you?
28.
All right, you're 28 years old. You're not a teenager. When someone says they don't want you anymore and they don't love you, move on. Because how long did you know her? How many years?
I've known her for over 20 years.
How long have you been in a relationship with her?
It was about 6 months.
All right, you've only known somebody for 6 months and you do this. You're gonna have to make better decisions. If somebody doesn't want you, that's the end of it. Move on. You can't make somebody love you.
Yes,
All right? Good luck to you. And by the way, did that neck tattoo hurt?
It kind of sort of did. I did it myself, honestly. And I did it more or less. It was anxiety, stress relief.
Okay, you did a neck tattoo on yourself.
Yes,
How
ma'am.
did you get the lettering not to be backwards? How were you able to do that?
I put a stencil on a piece of paper and I put it on there and then I did it with 2 mirrors.
Oh, okay. And what's the saying on your form?
It says, who are you to judge?
Oh, the judge.
Well, yeah. Yeah. Everybody gets only God can judge me. I went with the Bob Marley saying there.
Okay, no. I've heard that. I've heard his song. Awesome. Are you going to get any more tattoos?
I'm pretty much filled up as it sits. I mean, if it happens, it happens. If it doesn't, it doesn't. That's one of my professions. So
Okay. All right, go forth. And when people want to end a relationship, just move on.
yes, Your Honor.
All right, have a good one.
Thank you.
Yeah. Stephen Wellbarker. Who's it? Yeah. All right. We were here because he was going to hire you. Has that been done?
He did hire me and I filed my notice of appearance, I think yesterday, I think I got some discovery notifications. I haven't done discovery yet.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Wellbarker? All right, we'll come back on March 30th. That'll be the discovery date to make sure you have all the discovery. All right, thank you. Ms. Ferguson will give you your reset form, then your excuse.
Thank you.
All right, who's here on Johnny Webb? It seems like we were just having a conversation 2 minutes ago.
Yes, I'm actually stepping in for Case Kraus. I guess
All right.
there's something going on, but my understanding is there's three new cases haven't been indicted yet, so she's asking for a reset.
All right, do you know, well, I know you don't know, what are these new cases that need to be in or maybe indicted?
Judge, I believe one's tamper with government records. One of them is fraudulent use or possession of 10 to 49 items. And the last one, I can't remember.
All right, that's okay. That gives me an idea where we are. Ms. Ferguson, can I have a 30-day reset for discovery on Mr. Webb? All right, as soon as you sign the reset form, you're excused. Thank you.
Thank you.
All right, who's here on Victor Ramirez? Good afternoon. Where's Mr. Ramirez? Oh, come on down. So,
Sorry, I was in the 290th all morning.
right. So what is happening with this case?
Well, I've just gotten an offer from Mr. Jordan,
Okay,
reasonable offer. Right in the right place. Okay, but unfortunately, we have immigration issues. So we get a reset for that. So I talked to the public defender.
all right, Ms. Ferguson, can you see that he has immigration attorney? All right, is there going to be any issues with interpretations needed?
No, he's been here for a long time, but his card is lost, so. I don't want to move forward today, although Mr. Jordan has made very decent offers.
All right, Ms. Ferguson, on Mr. Ramirez, can I have a 30-day reset, please? All right, we're going to come back on March 28th. Before you leave, we'll make sure that an immigration attorney from the public defender's office or somewhere knows that you need an immigration attorney.
Thank you.
Thank you, ma'am.
You're welcome. Since when did they bring out purple handcuffs? Yeah, I'm like, purple's my favorite color. Who's here on Hector Aguilar? Oh, I haven't called it yet. Are you all ready?
Okay.
Okay. And state on Hector Aguilar, are you all proceeding on the same allegations in each motion?
Yes, Your Honor, it's the same allegation.
Okay. All right, court is calling 2019 CR 1152, 2019 CR 1153, State of Texas versus Hector Aguilar. Could I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense.
James Barrett for defendants.
And are you Mr. Aguilar?
Yes, ma'am.
All right, Mr. Aguilar, and each of the cause numbers, I'm showing you what's entitled Motion to Enter Adjudication of Guilty and Revoke Community Supervision. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Are you the same Hector Aguilar who's placed on deferred adjudication in 2019 CR 1153 for the offense of aggravated robbery on January 24, 2020 for a period of 10 years? Is that you?
Yes, sir.
And are you the same Hector Aguilar who's placed on deferred adjudication in cause number 2019 CR 1152 for the offense of aggravated robbery on January 24, 2020 for a period of 10 years? Is that you?
Yes, Your Honor.
State, are you proceeding on the same allegations in each motion?
Yes, Your Honor, we are.
All right. Defense, do you have any objection to the state reading the allegation and your defendant answering true or not true in each case?
None.
All right, state.
Violated condition number 2 on or about the month of December 2022 in Bexar County, Texas. The defendant, Hector Aguilar, did then and there fail to submit to drug testing as directed by the supervision officer and or a duly authorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
Your Honor, state waives all the violations.
Any objection?
None.
All right, in each of these cause numbers, did you understand by pleading true to violation of condition number 2, court could find it true, grant the motion and sentence you up to life in each of these cause numbers and up to $10,000 fine?
Yes, sir.
Knowing that, do you still wish to plead true in each of the cause numbers to violation of condition number 2?
Yes, sir.
In each of the cause numbers, the court will find violation of condition number 2 true. Is there an agreement?
Yes, Your Honor, to alter and amend to include state ISF both tracks.
Is that the agreement?
It is.
Probation with an aggravated robbery case, is he eligible for state ISF both tracks?
And just so the court's aware, that was probation's recommendation as well.
Okay. Okay.
Yes.
All right, thank you. So, Mr. Aguilar,
Yes, sir.
it appears that you may not want to be on probation. So if you want to, I will give you 5 years prison in each one of these cases and run it concurrent, or I can send you to state ISF both tracks. But if you have no intention of stopping your use of marijuana and not reporting, then really you're wasting everybody's time. You're wasting your time. You're wasting your counsel's time because you're just not going to follow through on probation. So it's up to you whether or not you want to go to prison for smoking marijuana, whether or not you want to go to prison for not reporting, whether or not you want to go to prison for not doing what you're supposed to do on probation. Some people prefer prison. They're like, let me just do prison and be done with it. So what do you want to do? Because you've been here before with me, and I'm inclined not to accept this offer and just send you to prison because you've been here before me in November for the exact same thing. So what would you prefer?
ISF.
All right. All right. This is what the court is going to do. Court will deny the motion in each cause number, alter and amend conditions to include state ISF, dual tracks. And just, even though I know what the charge is, sometimes felony drug court will accept, do a referral to felony drug court as well. Does anybody have another pen? My pen just died. Thank you. So we'll do a referral to felony drug court. Upon release from custody, he's going to be on GPS full. And once he's back, let's set a hearing, because then I can address whether or not I'm going to keep him on full GPS. Do you have any support system?
Yes, ma'am.
Who is supporting you?
My mom, my wife, and my brother. It appears that's credible. They were here this morning and
Mhm.
I talked to them plenty.
All right. Is there anything else you need from this court?
No, yeah.
All right, so probation, once he's released from ISF, I'm going to want another hearing with him so I can add different conditions and change things for him on based upon how he does and what's going on in his life.
Or the state ISF, we're not going to send him if he's accepted into felonies.
Now, if he's accepted in felony drug court, we'll let them set his conditions. All right, you better start, we're off the record, you better start doing better. Otherwise, you're going to find yourself in prison. People can't help you if you don't want to be helped. And if you're not trying, it's like, we'll move on to the next person. You understand?
Yes,
All right, good luck to you. Oh, thank you so much. Yeah, I guess I've been writing a lot. All right, who's here on Carlos Madrigal?
Okay.
Somebody from.
Okay, thank you. Where do I know that name, Madrigal? Is that from the, thank you, that's where that's from.
Oh,
Yeah, all right, so what's happening with this case?
Judge, we're here on a motion to set bond. There was an amended motions filed this morning that was accepted. I'll give a copy to
All right, thank you.
council. Judge, we're asking the court to set a bond. It's a little bit confusing, the history, so if the court wants to review that, then I can try to explain what happened.
All right, court is calling 2023 CR 2023 CR 1303, State of Texas versus Carlos Madrigal Hernandez. Can I have parties announced for the record for the state
Ruben Herrera for the state.
defense?
Only Adonis on behalf of Mr. Madrigal members.
All right. They are asked, defense is asking that a bond be set in this case. And so I have nothing on the docket sheet. So why does he not have a bond?
But what happened was that he was initially arrested on this case, on the stalking case and one harassment case, the 687-459. Back in July of 2022, he bonded out on those cases, July 6th on one case and July 8th on the other. What happened after that is that some sealed cases were unsealed and then sealed again and then unsealed again. And that resulted in warrants being issued in, I believe, October and September of 2022. When he was first released in July, he was put on GPS monitor with full house arrest. He was made aware of the warrants, but no one, well, on house arrest, and no one ever came to get him. He actually appeared in court, in county courts, on those new cases, and he was never arrested. So in January of this year, he told his bondsman, look, I'm just going to surrender myself on these new warrants and let's get off my bonds. So that's what happened. The bondsman got off his bond. He did not have any problems with his bondsman. He had no issues as far as reporting or paying to the bondsman. He was just frustrated and he asked the judge, asked the bondsman to get off his bond. He did. The county court doubled their bond. This court remanded him without bond and issued a warrant.
All
So
right.
he's been in jail since January 27th. Yes, on January 27th on this, I'm sorry, January 30th is when he surrendered himself to the county.
All right, and what are these sealed cases that were sealed, unsealed, and then resealed?
One is a harassment and the other one is a terroristic threats. And both those offensive dates, Judge, predate the felony stalking case. Those offense dates are, the stalking date is May 17th, 2022. The harassment dates are December 13th, 2021, which is what he was already on bond for. And then the ones that were sealed and unsealed, one offense date is March 1st, 2022, and the other one May 11th, 2022.
All right, state, are you going to be in agreement to a bond being set or no?
Yes, ma'am.
Okay, so before the court sets a bond, because I'm not the person who originally set the bond on the stalking case,
Yes.
because I would have wanted to know what happened with those other cases and whether or not it's the same complainant and what's going on. So I'm going to personally need to hear from the complainant in this case so that I can be assured that they know what's going on. So how long do you need to make sure that that person can appear?
We can make calls today. I'm not sure what the complainant's schedule will look like.
Well, I wouldn't expect it to happen today.
Of course.
So this is what we'll do. It's going to be reset. If you'll get in touch with your complainant and counsel, if you'll come in on Monday, and we'll find out what date it's going to be on Monday. Is that enough time?
That should be enough.
All right, so we'll, this case won't be set for Monday, but counsel, if you'll come to court on Monday and we'll figure out what day we can set this so I can actually hear it.
Okay, fair enough. And I believe the state's attempted to contact her before without luck, and I know we've attempted without luck.
Okay, all right, we'll see. So I can make sure that everything's good.
Absolutely.
Okay,
Thank you.
all right, thank you. All right, Norma, so on that one, he doesn't have to be brought over. It's just for the defense attorney for them to confer and get us a date. You can put it on the docket, but not request the defendant. Joshua Clark. All right, court is calling 2019 CR 0925W, State of Texas versus Joshua Clark. That parties announced for the record for the state. Defense.
Attorney Bill Simmons for defense.
Are you Joshua Clark?
Yes, ma'am.
Showing you what's entitled motion to enter adjudication of guilt and revoke community supervision, and state's motion to supplement pending motion to enter adjudication of guilt and revoke community supervision. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Joshua Clark who was placed on deferred adjudication in cause number 2019 CR 0925W for the offense of aggravated assault with a deadly weapon on February 22nd, 2019 for a period of 8 years? Is that you?
Yes, ma'am.
All right, state.
Your Honor, the state would be proceeding on a violation of condition number 2. In that honor, about the 25th day of October 2022 in Bexar County, Texas, the defendant Joshua Clark did then and there fail to submit drug testing as directed by the court officer, supervision officer, and or a duly unauthorized agent of the court in violation of condition number 2.
How do you plead to that? True or not true?
True.
State.
Your Honor, the state in exchange for the defendant's plea of.
What will you waive?
We waive all other violations. Your Honor.
Any
No
objections?
objection.
Did you understand by pleading true to violation of condition number 2, the court could find it true, grant the motion, find you guilty, sentence you up to 20 years in prison and up to $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 2?
Yes, Your Honor.
Court will find violation of condition number 2 true. Is there an agreement?
No, Your Honor, we're going over to the court. They had a recommendation.
All right, state, what are you requesting?
Your Honor, the state would recommend revocation of the defendant's probation and recommend 4 years.
All right, and defense, what are you requesting?
Your Honor, we would ask the court to consider to continue him on his probation. We know it's a lot of things that were that he's being accused of, but there's a reasonable explanation for a lot of those. So we would ask the court to consider not adjudicating him guilty and continuing him on his probation, or in the alternative, if the court were to find him guilty, if they decided to do a sentence, he has expressed some willingness, if the court was willing enough to do some house arrest to address some of these issues.
All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? You can lower your hand, state your name for the record.
Joshua Clark.
Do you want to go to prison?
Oh, ma'am.
Then why are you not doing what you're supposed to be doing on probation?
I'm doing the best I can, but the job I was working at that time.
Well, no. Doing the best you can is not testing positive for marijuana. I'm on probation. I know I'm not supposed to take marijuana, but I'm using it anyway. Doing the best you can is not this number 2 that I have here. And I'm not considering any of the others, but you have testing positive for marijuana, submitting dilute samples, hanging around people you're not supposed to hang around with, which means you're hanging around people who have criminal history. And unless that's your family members, you're supposed to cut them loose. Because I understand sometimes people's moms and dads have been to prison before and they live at their house. That I understand, but you just hanging around people who have issues, that's an issue for the court. So why shouldn't I send you to prison?
I have a note too about the situation, what happened on that situation, but I go to school and I prefer to be free.
Well, everybody prefers to be free. I don't know anybody who's at the jail or at prison who doesn't prefer to be free. But my problem is you're not doing what you're supposed to be doing on probation. And I'm trying to figure out why should I continue you on probation?
Ronald, he had a letter he wanted to have put into the record. I told him I would ask the court if they would consider it. So they have seen.
All right, do you have any objection to the court reading the letter? I'll read his letter. What school are you enrolled in?
I do an online school called, it's ISSA, it's, to be a master personal trainer.
All right, is there anything else?
Uh,
Where are you gonna be living?
I stayed at the address.
Well, I guess you shouldn't stay at that address anymore if you don't know who's in there.
If it would please the court. Again, if the prosecutor's mind, without getting into the court's consideration, there's that story behind what happened that, because it was an isolated incident. That somebody who did not live there showed up there to the house. The house is his uncle's house. Correct? Yes, sir. Okay. And it's his uncle's house and that he didn't live there. And he did, and that person who person who brought the stuff there, he's the person who brought it there. So it was an isolated incident.
I mean, well, here's the thing. Does he have some other charges that are pending or coming down?
There's an evading arrest from that night. Oh, no, not from that night, Judge. I'm sorry, from January. He had the warrant. He didn't know that he had the warrant originally, and this is in the report. Originally, there was an unmarked vehicle. There's some question. Okay, I have not seen the video, Judge, around. In other words, the first car was unidentified and there was an undercover. They kind of had recognized him, knew they had a warrant. He saw he says that he saw the unmarked car. That's why he started running. There's some question about at what point did he see a marked vehicle and whether or not he kept running. So we can't, because I don't have that evidence here.
All right, so here's the thing. I don't have enough information to make a ruling on whether or not it should go along with the state of the defense. Now, mind you, I'm not going on any of the other allegations in here, but of course, I can't help but see this allegation where there is a number 11. I mean, have you guys seen number 11
Yes, sir. I believe.
and 6C? And
16,
yes, and number 11. I mean, so it appears that there may be something else going on. I don't know if there's anything else going on. So I'm going to need some more information from you all before I make a decision on whether to continue him or revoke him as the state is requesting, because I don't have enough information. So I've accepted his plea of truth, and we will call that back. And if you all can, if somebody wants to have an officer come in and testify, or if both parties agree to have me review a police report, I'll be more than willing to do that. But I don't have enough information to make a decision on whether or not he should be continued or revoked.
And just what I would say is, just for the court's knowledge, the 6C revolves around those, all those allegations are about the night when the officers came to his house and where he lived, where he's been on, even when he was on intensive supervision, where they were coming to check to make sure nobody was there and they weren't. That's the home. All of these allegations arise out of that incident. I reviewed that report with probation to where they started, but that's where all of that stems from. So, and I wouldn't take issue if the state was with the court being able to see that report. I'm just not sure if the individual who ended up with those charges, I'm not even sure if it's relevant. I'm saying that it was.
All right, so what's going to happen is we're going to reset this case. And I see that this is it appears that the allegations of what may or may not be new charges are with criminal trial division. So I don't know if you all want to check with them and see if they have any information about the other allegations that are in this motion. So I'm going to recall this in 2 weeks. If you all want to come back sooner than 2 weeks, just let the court know, just as long as I have the information and I'll make a decision.
Yes, sir.
All right, Ms. Burgess, can I have a 2-week reset on this case, please? I'm sorry, where? All right, we'll come back on March 9th. All right, who's here on Romaldo Martinez?
I am wrong.
And then after that, Mr. Stenberg will take up your case, and then we are closed for today. Anybody who didn't make it, did not make it. Court is calling 2021 CR 2493, State of Texas versus, oh, he's not here.
No, Your Honor.
It's a
Oh.
bond.
It's a bond.
Oh, okay.
Yeah, it's off docket, Your Honor.
He was
Ah.
taken into custody today at probation.
And I think that these, as counsel asked us for a bond to be said, and we're in agreement.
Oh, we're not on the record.
Sorry, that's
So-
fine, that's fine. But just get a bond set, and then he'd like, I'm trying to bring him in next week.
Hi. Hi. All right, and then who's here on Jayden Green? Yes. And then Mr. Steinberg, what's happening with your case? Okay,
Yeah.
All right, so yes, on Jayden Green.
Yes, Your Honor. I tried to contact Brittany yesterday. She was out. I had.
She was
Ruben here?
Yes. So we have jury trial.
Next week.
Yes.
Yes, he's been approached to go to Houston for a recording a situation on Saturday. So this is just permission to travel for this weekend. We relaxed his.
Okay, so where is he going?
Houston, the
For what
address is
purpose?
in the motion, to be, to record, and I have the person's name, that he's going to
All right, state
the
here.
address.
Here's this, see if you have any objection.
We agreed to reduce into travel only, the still only thing in here. This is so completely opposite side. He's just going from tomorrow night to Sunday. And we'll be back in about. Just asking about him. So, and it's with this.
Thank you, Ron.
You're welcome. And then come on down, Mr. Steinberg. Your client is Juan Ratana. All right, Ms. Ferguson, I need a jury trial setting on Mr. Ratana. I think this is criminal trial division.
I think it's family violence.
Oh, it is? How much time do you need for trial?
I'm sorry to interrupt. I think the date was already set.
Ah.
So, Mr. Kinberg was just wanting.
Oh, the date is April. We'll see you then for your jury trial. Your plea deadline date has expired. Court will not accept any further plea bargain agreements in this case without good cause. You understand? All right. All right. Do you have any objections to his traveling?
Yes, Your Honor, we would object, for the record.
Oh, we're not on the record yet. When is he supposed to travel?
Friday night to drive to Houston. He's recording on Saturday. They're shooting the video on Saturday. He's being paid $3,000 plus $500 for hotel travel. He will come back Sunday. We have trial set Tuesday. He's made every court appearance.
Has he traveled before?
Well, we have slowly, gradually gotten him off, and now he's on tracking only with just the modification to restrict the alleged complainant address. We did that in November. So he's on GPS tracking only. We're just asking for permission to go to Harris County.
All right, so he's tracking only. Is there an issue with him traveling for work?
Your Honor, I don't have any information on the case, other than what I have from, Mr. Mitchell. We make our objection for the record, Your Honor, but we would defer to the courts.
All right, do you want to call Ms. Mitchell?
I can reach out to her very quickly.
All right, so just hang around.
Okay.
All right, Deputy Laura, we are done for today.